2024, an election year like no other. From the candidates to the issues, from voter integrity and analysis, we'll discuss debates, trends, patterns, election laws, and more. This is Vote 2024, Path to the Polls.
Thanks for joining us. The Supreme Court deciding once and for all whether former presidents can be prosecuted for official acts while in the White House. It's being called a decision for the ages. The justices in the nation's highest court heard oral arguments as to whether Donald Trump is immune from prosecution in a case charging him with plotting to overturn the results of the 2020 presidential election. It is history in the making. A ruling is unlikely before June, and the case is unlikely to be tried before voters go to the polls in November. On Path to the Polls, we explore that impeachment clause, answer the question, what is this about Richard Nixon, and why the discussion is not for the reasons you might think. Do the arguments that Trump's lawyers make for the former president to have immunity have merit? Will politics infiltrate the high court's ultimate decision? And what are the differences between personal acts made by the occupant of the White House and presidential decisions? I'm News4JAX anchor Bruce Hamilton. We'll explore those questions and more with my guest here on Path to the Polls, constitutional law expert Rod Sullivan of the Newman Group. Thanks for being here.
Thank you. Good to be here.
Let's start with what the Constitution states on this matter. Article 1, Section 3, Clause 7. It reads, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. The justices have to see how this weighs in the Trump immunity case. A lot to digest there. Let's break it down.
Well, first of all, you need to look at it the way the people who voted on the Constitution saw it back in 1796 or whatever. They read something called the Federalist Papers, and the Federalist Papers were a group of letters to newspapers, letters to the editor, op-ed pieces by various people, including Alexander Hamilton, as to how to interpret these clauses. So the number one Federalist paper that addresses this question is number 65, written by Alexander Hamilton. And he made it fairly clear what he thought this clause meant. He thought it meant that if a president commits a criminal act in office, first he has to go to the Senate and be impeached, and then afterwards he can be tried criminally. And he has a very lengthy explanation for why he thinks this is. He says there's really no way that a federal official can get a fair trial, either before a fair judge or before a fair jury, especially in a hotly contested issue. Therefore, to put a break on this system, we need to send it to the Senate, where people are elected for a period of 6 years, and let the Senate go ahead and decide that this person needs to be impeached. And you can be impeached after you've left office. You don't have to be in office, because impeachment not only removes you from office if you are in office, it prevents you from running again if you're impeached. So his interpretation was the order of things is if somebody commits a crime in office, it goes to the House, issues articles of impeachment, the Senate tries the case. If they can get a 2/3 majority, then the person is impeached, and then they can be prosecuted criminally. That's what he thought. The question is, do the Supreme Court justices think that now? And I would suggest that from the questioning, unless they were not questioning on this topic, it didn't appear like that argument got much traction. It appears like they were taking the position that we're going to divide the president's acts into personal acts and public acts. And that he's going, and you have to understand that immunity is not a strange concept. Everybody who is in this case, virtually everybody has immunity. Those Supreme Court justices sitting, hearing this case, they have immunity. The prosecutor bringing the case, he has immunity. Mr. Merrick Garland, the Attorney General, he has immunity. So immunity is not that strange a concept. And the question is, does a president have immunity? Well, they already decided back when Nixon was president that the president has absolute immunity from civil lawsuits arising out of his presidency. And that was in a case called Nixon versus Fitzgerald. So that's the general law with regards to civil matters. Fitzgerald was a federal employee who got fired, and he said it was in retaliation for him telling Congress that not Nixon had done something wrong, but that Lyndon Johnson had done something wrong. And he sued Nixon, and the case went all the way up to the Supreme Court. It took 8 or more years to get there. Nixon was already out of office, and the Supreme Court said this was one of Nixon's official acts while he was president. It doesn't matter why he fired him. He's got immunity. So that's the law with regards to civil immunity. Trump came to the court and said, you know, why should there be a different standard for civil immunity and for criminal immunity? And we think that President Trump should have criminal immunity from all of his acts while in office. Well, that argument got zero traction. As a matter of fact, the very first question out of the box sort of set the stage for the whole thing. Justice Thomas, who's a relatively conservative justice, was given by Justice Roberts the opportunity to ask the first question. And he asked Trump's attorney, where in the Constitution does it say that the president gets immunity? And the attorney for Trump had to look at him and say, well, it's not in the Constitution. And so Justice Thomas, who is a textualist, looks for the basis of any federal law in the text of the Constitution, sort of said, okay, well, if it's not there, then how do you come here claiming he has immunity? And that's how the argument kicked off. That's how you knew from the very start that this case wasn't going to go for Trump in the Supreme Court. But it's not a slam dunk the other way. I mean, what is going to happen here, in my opinion, is the court's going to come back and it's going to set the contours of what criminal liability there is for a president. And I think what they're going to do is they're going to say, okay, there's no absolute immunity for these criminal acts, if they are criminal acts, and we can't judge because we don't have any facts in front of us. All we have is an indictment. There has got to be some immunity for his official acts. I mean, one of the president's duties is to see that the laws are faithfully executed. And if he, as a president, said, well, we think that there was election fraud in Pennsylvania or Arizona or any of the other states, and I have the obligation as the president to see that those frauds are corrected, well, those would be official acts, and therefore he'd have immunity, civil and criminal immunity from those. However, if they were not in furtherance of his duty to execute the laws faithfully, then they might be personal acts. They might be just trying to overturn the election for his own personal benefit, and therefore maybe he won't have immunity. So I think what they're going to do is they're going to say, okay, no absolute immunity. There's going to be some qualified immunity, and this needs to go back to the district court to make a factual determination as to which of these acts constitute official acts and which constitute private acts. And that's what I think will happen. And I think the district court judge who initially said there's absolutely no immunity at all is going to have to hear this case under the new rules set out by the Supreme Court. All
right, this blows out my whole line of questioning, so I've got to get to this.
Okay.
Does this open up a Pandoras box when it comes to, you know, what the president can and cannot do, and, you know, can they be criminally charged, and, you know, what kind of restrictions are they under?
Yeah, that was the very first argument that Trump's attorney made. If you do this, it's going to lead to a cycle of recriminations. What about Barack Obama? He killed a United States citizen with a drone outside of the United States while he was president. Is that a criminal act? Can he be prosecuted for that? How about President George Bush? He said there were weapons of mass destruction. That led us to a war. Can he be criminally prosecuted for that? And he had many, many other examples of presidents who took actions while in office.
Joe Biden when he's out of office.
And Joe Biden, yeah, well, that's the next thing, is the shoe that's going to drop. I mean, can Joe Biden be prosecuted if he leaves office in 2025? Can he be prosecuted, for example, impeding the indictment of his son and his brother on charges of bribery or drug use or possession of firearms or whatever? And you know, is this going to lead to a cycle of recriminations that's going to go forward? And that was the point that Justice Alito made. He says, you know, we know what happens to countries which start using the criminal laws to bring about political change and enforce political policy. Those are countries that are on the downward spiral, and it just leads to one recrimination after another. So we don't want to do that. And then Justice Kagan sort of jumped in as a response to Alito and said, well, what if he sells nuclear secrets? What if he orders there to be a coup? Shouldn't there be criminal responsibility for that? And of course, everybody said, well, you know, that seems different. This is one of the reasons why I really think the impeachment clause argument has a lot of benefit, because let's say the president did order a coup, and he's reinstalled as president. Well, what is the remedy then? Well, I think the remedy is that the House of Representatives brings charges against the president. It goes to the Senate, and if 2/3 of the senators agree, then he's impeached, and then he can be criminally charged for these actions. But like I say, I don't really see there being, 5 votes for that particular argument. It just didn't gain traction during oral argument.
But wasn't it Justice Kagan who asked whether or not, the issue of a coup was okay? And Sauer, who is Trump's attorney, said, yep, he's got that right.
Yeah, there comes a point when maybe you need to back off on your zealous arguments. And he wasn't the only one who made zealous arguments. Of course, the attorney who represented Jack Smith before the Supreme Court was almost as zealous on the other side, which was, Trump's got no immunity for anything. He can be prosecuted for anything. He's just an ordinary citizen. So I don't think either one of those extreme positions is going to gain traction with the court. So that's why I think it's going to be a decision that is going to, it's going to go against Trump. It's going to go back to trial, but they're going to set the contours of what it is that he has immunity for and what he doesn't have immunity for.
So we'll talk more about that. And you're thinking it's going to go back to the Court of Appeals and District Judge Tanya Chutkan. So after hearing some 3 hours of legal arguments, the court seemed a bit divided. On the one hand, ready to reject the former president's claims of sweeping immunity and the broad protections that he wants, but also hesitant to give the special counsel, Jack Smith, carte blanche to pursue charges.
Yeah, that's right. The court said, look, first of all, you have to understand that this case comes to the court with no factual background on the record. I mean, all the judges know is what they've read in the newspapers and what they've seen in, news reports and things like that. This was an indictment, and this was a motion to dismiss the indictment, and therefore the court has to accept as true those matters that are alleged as facts in the indictment. So what they're saying now is we don't have any facts. We have, feelings, and we have news reports. We don't really have any facts. We want to send it back to the district court, and we want the district court to conduct a hearing. They call it a Brewer hearing or whatever. We want the court at the lower court to look at this and take some evidence and then come back to us and tell us what it is that you think is an official act and what you think is a private act and why. What evidence supports that? And so I think maybe we're going to end up with that hearing, and that's going to go back up to the district court, and that's why this case will likely be delayed until after the election.
So that is the other big takeaway. A lot of people wanted to see some sort of a decision that would allow some sort of finalization before November, and you don't think that's going to happen?
I don't think so. I'm not putting it beyond the realm of possibilities, because I think the district judge might likely drop everything and make this her first priority. But even if she comes out with the order that expresses what the Supreme Court said, then it has to go again through the D.C. Court of Appeals and then back up again to the Supreme Court. So probably none of that can occur before the November elections.
All right. Back to the other important thing here. Much of the hearing focused on whether there should be a distinction between official acts by Trump pursuant to his presidential duties and his private conduct. And that's one of the things that the court is going to wrestle with.
Absolutely, yeah, that's going to be one of the dividing lines between the two. And the other thing is, we have to put ourselves back in the nation between November and January. And what did people know? So a lot of things that are charged against Trump is that he said there were 205,000 more votes cast in Pennsylvania than there were registered voters. He said there were 30,000 votes cast by illegal aliens in Arizona. Now, on January 6th, did anybody know those statements not to be true? I mean, we'd heard them, but do we have any facts or evidence? Was there any investigation to say that that was wrong? And a lot of these opinions, including the D.C. Circuit's opinion, comes out and says, well, we know now, 2 years and 7 months later, after multiple civil trials throughout the nation, we know that these things aren't true. But that's not the real test. The test is, what did you know was true or not true on January 6th? Were these totally implausible charges on January 6th? I would suggest to you that if you put yourself in the shoes of somebody in a state legislature looking at this on January 6th, the answer to the question is, no, I've heard these charges. I want some more evidence. I want to find out what the facts are.
Caleb, I'm going to take a break after I ask this next question, just so you know. But picking up on what you just said, Justice Department, of course, charged Trump with federal crimes in connection with the fake electors scheme. But his lawyers said he absolutely had the right to go ahead and do that. Those comments are a remarkable embrace of a plot that may seem as a corrupt scheme to overturn the will of the voters. Isn't that shocking?
Should we get back to that afterwards?
No, let's do that. Answer that now, and then we'll take the break.
No, this idea of alternate slates of electors is really well established in U.S. government. The most shocking, not shocking, most complete example is the election of 1876 between Hayes and Tilden. There were three separate states that issued different sets of electors. There was Florida. We were right in the middle of it. There was South Carolina, and there was Louisiana, and then there were two smaller states, Oregon and Vermont, all of whom had different slates of electors. So what did Congress do? Did they, bring charges against these alternate electors? No, what they did is they set up a commission, and we're going to determine which of these electors are the real electors and which are the alternate electors, or we call them fake electors, which are the ones that we're not going to accept. And then this 15-person commission, which consisted of Democrats and Republicans from the House, Senate, and the Supreme Court, listened to the evidence, and they said, okay, we're going to accept these electors, we're going to reject these electors, and we're going to give the election to Rutherford B. Hayes, who then became President of the United States. So one of the most interesting ones is the one in Vermont. In Vermont, one of the electors from Vermont got disqualified because he was a postmaster, and you can't be a federal employee and an elector. So a congressman from New York, not a congressman from Vermont, a congressman from New York raised his hand and says, I am the elector from Vermont that replaces this guy, and I vote for so-and-so. I mean, that's out and out fraud, right? He's not even from Vermont. Right, he's in D.C., he's from New York, he wouldn't have any connection with Vermont. So they said, no, we reject you as an elector. Okay, well, that's probably what should have happened. But nobody said, and you committed a crime and you need to go to jail. That never happened. Same thing happened, a similar thing happened in 1960, the election between Nixon and President Kennedy. Hawaii sent in two sets of electors. As a matter of fact, you know where Trump's team got the forms for putting in a separate set of electors? They took it from the Democrats in Hawaii in 1960. They copied it word for word, and they submitted these forms the same that the ones in Hawaii submitted, and that's where we're at with these fake electors.
This is nothing new.
That's not really new. I mean, there was the 1880 election, 1876. There are any number of elections where there have been alternate slates of electors, and somebody has had to come forward and decide which electors they were going to accept. And Arizona has said, not only do you alternate electors, not only are you fake, not only are you fraudulent, but you're criminals. We're going to charge every single one of you with a crime for saying you were an elector when you really weren't. Well, that's never happened before. I mean, we're 234 years into this experiment in democracy, and no elector has ever been charged with a crime for listing themselves as an elector, as an alternate elector, as a fake elector. So we're venturing into new territory here. And when we venture into new territory, as Justice Alito said, we may be on the downward spiral toward third world nationhood instead of a continuation of the 234-year experiment in democracy we've been involved in.
Who would have thunk we were going to get a history lesson today, but we are. All right, who are the justices to watch? That, when Path to the Polls continues. Welcome back to Paths to the Polls. My guest, constitutional law expert Rod Sullivan. So, the liberal justices clearly were not impressed with Trump's absolute immunity claims. Who do we watch here to see where this ultimately goes? Kavanaugh, Barrett, and the Chief Justice, John Roberts. I'm especially thinking John Roberts.
Yeah, I mean, this court seems to break down on this case 3-3-3. And certainly the three more liberal justices, Kagan, Sotomayor, and Jackson, they were not buying anything that Trump's attorney said. The three more conservative justices, though, it might be, you might be tempted to say they're going to vote for Trump, and I'm not really sure they are. I'm not sure you're not going to get at least a 9-0 decision on one of the issues, which is, does the president have absolute criminal immunity from any acts in office? I don't know that I saw a vote for that. I mean, you have Thomas coming out and saying, I don't find immunity in the Constitution at all. And you would think that Thomas would be a fairly safe vote for Trump. And so you could, on that one issue, get even a 9-0 vote. But I think it's going to split 6-3 at least, and that Barrett, Kavanaugh, and Roberts will probably side with the more liberal justices in their interpretation of what acts get immunity and what acts don't.
So let's talk about the public's perception. According to a new Politico Ipsos poll, Americans overwhelmingly reject Trump's presidential immunity claim. 70% of respondents rejected this position, including a large plurality of Republicans. Only 11% of all respondents endorsed Trump's position that presidents should have criminal immunity for conduct while in office, and they were largely Republicans. Do you take that to mean that the public sees the claim for immunity as an absurd matter of law?
I don't. The way I think that people are looking at this is I don't think they understand the impeachment clause and its import in this, because even the founders didn't believe that presidents had complete immunity. They only thought that the president had immunity until he was impeached, and then after he was impeached that he had criminal liability, and that they wrote into the Constitution, the impeachment clause. I think if most people looked at it like that, they would probably say, okay, I understand that. There's a check on presidential power. The very first check on presidential power is the Senate. If the Senate thinks by a 2/3 majority that what was done was criminal, then they can go forward and prosecute him. And 70% is important because let's take Clinton, okay? Clinton was charged with perjury, and that went up on impeachment. It went to the Senate, and only 55 members of the Senate voted that that was perjury and to impeach him. So he was not impeached. He was not removed from office. He was not convicted. After that, if the argument is that the president is still criminally liable for his acts while president, then the Bush administration could have come along and said, well, you know, you weren't impeached, but we're going to charge you with perjury and convict you even when you're out of office. That didn't happen. And I think the reason that didn't happen, and look at this case too, they waited, meaning Garland and the Department of Justice, they waited until after the Trump impeachment was done before they brought criminal charges. As a matter of fact, they waited until he announced for re-election. You understand, this was 2 years. Trump was silent about whether he was going to seek re-election for 2 years and 7 months. And then he came forward, and nobody was saying that he's going to be indicted. They didn't bring an indictment. The average amount of time between a case coming to the attention of the U.S. attorney and an indictment coming out is 60 to 70 days. This time, it took 15 times that. Well, what were they waiting for? They had all the facts they needed. They could have indicted him at any time. What were they waiting for? They waited for him to declare he's going to run again. If he said, I'm not going to run again, this may never happen. But he comes forward and he says, okay, I'm going to run against Biden again. 2 days later, Merrick Garland says, we're going to appoint a special counsel to prosecute you. Why? Well, because you're seeking, he said, I'm doing this now because he's announced that he's run for president. And that's why we need a special counsel to investigate him. So I would suggest to you that the idea that the president could not be charged for criminal acts, and the majority of people think that he should be able to be charged for criminal acts, sort of changes if you put in the equation, shouldn't he be impeached first? Shouldn't the Senate come forward with a supermajority and say, yeah, these are criminal acts, and we're going to remove him from being in office or ever serving again in office, and then the criminal charges ought to come. So maybe that's why Merrick Garland waited 2 years and 7 months to seek an indictment, because he wasn't impeached, and therefore he was concerned that maybe he couldn't bring criminal charges until there was an impeachment. Clinton wasn't impeached, so charges were never brought for his perjury, which was committed while he was in office, possibly because he wasn't convicted on that charge.
So is the argument that this is indeed political valid?
Oh, there's no question about the fact that, in fact, if you look at Federalist 65, most of what Federalist 65 says is we need this check, this impeachment check, because a sitting president cannot get a fair trial. In the first election that Trump ran against Hillary Clinton, 96% of the voters in the District of Columbia voted for a candidate other than Trump. He runs for re-election, and 95% of the District of Columbia votes for a candidate other than Trump. There's no way a jury in District of Columbia is not going to convict Trump. I mean, that's just not going to happen. Mm-hmm. If charges are brought and it goes to a jury, the D.C. jury is going to convict him. I mean, when I was in college, I worked as a private investigator for criminal defendants in the District of Columbia. I can tell you that there is no way that a District of Columbia jury is ever going to acquit a Republican office holder against whom charges are brought. And as a matter of fact, I asked this question to ChatGPT. Can you name for me one Republican official who went to trial in the D.C. circuit and was acquitted of their criminal charges? And ChatGPT says we cannot find any response to your request. So apparently there's just doesn't happen. This also was an issue with regards to Biden and his storage of documents in his home in Delaware. You know, we all focused on the clause in that report that said that he is befuddled and an old man and now everything else. But one of the things that was sub silentio in that report is we can't convict this guy in the District of Columbia. It's just a waste of time. You bring a charge against Biden in the District of Columbia for the exact same thing that Trump did, he's not going to be convicted.
So there was a double standard.
Well, it's a political standard. Mm-hmm. I mean, these are all of these cases around the country are brought in jurisdictions with prosecutors who are Democrats, supermajority of voters who make up the jury pool who are Democrats, who are slamming Trump repeatedly, whether it's a civil judgment, whether it's a criminal judgment. Any place that Trump goes in Atlanta, New York City, Washington, D.C., he's going to be convicted, no matter what it is. Or he's going to be found liable no matter what it is. It's the way that the nation splits up politically. I mean, the cities are dominated by Democrat voters and consequently and Democrat prosecutors, and therefore those are the places where Trump can really not get a fair trial.
All right, let me ask about the question of the Supreme Court's ability to get things right. Americans apparently don't trust the court. Again, that Politico Ipsos poll, 70% of respondents rejected this position, including a large plurality of Republicans. Only 11% of respondents endorsed Trump's position that presidents should have criminal immunity for conduct while in office. They were largely Republicans. That ought to be dispiriting for the justices, assuming they care. Do you trust the court to get it right?
Yeah, if you listen to the questioning, particularly from the conservative justices, the prosecution kept trying to bring that back to the facts of this case. We had January 6th, so on and so forth, and the justices kept saying over going, we're not deciding this case regarding Trump and January 6th. We're making a rule that's going to last for the ages. So you need to be prepared for whatever rule we have, that there are going to be recriminations down the future, and we want to get it right. We want to make sure that this republic survives, that we don't head down this circling spiral of recriminations and prosecutions and settling political difference in criminal courts. And so therefore, I think they're going to get it right merely because they have a longer telephoto lens. They're looking farther out in the future than this particular case. And that's why I think that you could get a 9-0 decision on the question of whether there's absolute immunity for criminal charges. On the other question is, how do they write the opinion? Where do they draw that line between what's private conduct for which there is no criminal immunity and public conduct for which there is? And Trump's attorney suggests that you need to give them the president the broadest possible discretion possible. And he was quoting from the Nixon versus Fitzgerald case, which is the one that decided civil immunity. The Nixon versus Fitzgerald case said that when you're looking at this issue, you need to err on the side of the president. You need to assume that virtually everything he does in his official capacity does in fact have immunity. And the justices seem to, certainly the conservative, the liberal justices rejected that position. Oh, that's just a carte blanche. That just turns the presidency into a criminal conspiracy. Justice Jackson actually said that. And so I don't think that's, they're not going to accept that argument. So is it going to be political? I mean, everything in this case is political. Is the Supreme Court going to break down along strictly political lines? I don't believe it is. From the questioning that I heard, the import I got from people is we need to get this right forever. We need to, not just for this case, we need to set whatever the rules are, and they need to carry on forever.
All right, so while it may ultimately determine Trump's legal fate and likely set the rules of criminal exposure for future presidents, this is not just about Donald Trump.
No, that's what the questioning of the Supreme Court justices made clear. They really didn't want to hear about the facts regarding Donald Trump. They wanted to hear the issue of how are we going to divide criminal responsibility for the future that's going to last forever. And I think they're going to come out with a line that's drawn that will make nobody happy, but will probably be one that will survive into the future.
So we should know come June where this lands. Shall we revisit it then?
Absolutely. I'd be glad to come back.
Always a pleasure. Thanks. Appreciate your time. And appreciate you watching on Path to the Polls on YouTube, the News4JAX YouTube channel. News4JAX Plus, news4jax.com. If you'd like to weigh in, there's a comments section. If you're a News4JAX insider, we'd love to hear from you. Thanks for watching.
See why every day more people are choosing News4JAX, Northeast Florida and South Georgia's #1 source for local news.